So we have a major update in one of the most important Second Amendment cases that's going on this term and will probably be a landmark case for the Second Amendment. Oral arguments have now been held in the case Wolford versus Lopez, which is the Supreme Court case challenging Hawaii's attempt to ban concealed carry directly after the Supreme Court issued their Bruin ruling. The Supreme Court has now heard these arguments, and based on the tone of the questioning, this case could determine whether states are allowed to effectively nullify the right to carry through these types of default bans. So let's break down what happened during the arguments and maybe what the outcome could be based on my opinion. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. Also, you can click the like button. Clicking the like button, if you enjoy this type of content, just simply tells the algorithm that you appreciate this and should share it to more people. I also want to thank one of the main supporters of this channel, which is First Form. You guys know that First Form's an amazing company. They believe in the Second Amendment. They support this channel, but also they have amazing supplements. So maybe if you have a New Year's resolution, you're trying to get healthier. Right now I'm trying to do the same, working out. I've already lost 15 pounds since the beginning of this year. But if you're kind of on that journey as well, you can check them out using the link down below. Check out some of their supplements. Their protein powder is my favorite thing that they offer. Again, you can check that out using the link down below. And if you order any supplements, you can get a free 5-pack of protein sticks. Now, as I mentioned in the intro, in this video, we're going to be talking about the next big two-way case, which will be decided this term. This case challenges Hawaii's response to the Supreme Court's 6-3 ruling in New York State Rifle and Pistol Association versus Bruin. Now, after Bruin struck down May issue CCW licensing schemes, Hawaii passed a new law creating this default prohibition on concealed carry. Under this new law, licensed concealed carry holders cannot carry firearms on private property that is open to the public unless the property owner gives them express permission in advance. Now, that law flipped the historical traditional rule on its head. Historically, carry was lawful unless a property owner posted maybe something like a no guns allowed sign. Now, under Hawaii's new framework, carry is automatically default unlawful essentially everywhere unless a property owner opts in and posts a sign that says, yes, you can conceal carry at this location, or gives you express permission to do so. Now, on review, the Ninth Circuit upheld this structure. The en banc panel in the Ninth Circuit decided to deny review to this case, and eventually this made its way to the Supreme Court, and the Supreme Court granted review to this case. The central question before the Supreme Court was whether that default prohibition that Hawaii put in place is consistent with the Second Amendment and also what the Supreme Court just said a couple years ago in that Bruin ruling. Now, here's what happened during the oral arguments that happened at the end of January. There were several Supreme Court justices that pressed Hawaii on whether this law effectively kind of wipes out public carry. Is this kind of a default ban on concealed carry? Now, there were also repeated questions about whether this operates as a near total ban, whether Hawaii is relying on, improper laws like hunting trespass laws that are historically irrelevant. Also, there were some critical questions about whether the Reconstruction era laws and statutes that were used by Hawaii as potential analogs were discriminatory and improper historical support that a state like this should put forward for this type of law. Hawaii's position leaned heavily on property rights and trespass laws, but the pushback from the Supreme Court focused on something kind of more fundamental. Is this truly about property rights, or is this kind of a workaround designed to make carry nearly impossible, and Hawaii is just trying to hide behind these other historical analogs that maybe also just are not good fits? And this also revolves around one of the core constitutional issues that was brought up in the analysis that was outlined under Bruin. Under Bruin, once the Second Amendment's plain text covers the conduct, here the conduct would be carrying firearms in public for self-defense, which is conduct protected by the Second Amendment, as pointed out and set as precedent under Bruin. The burden then shifts to the government. Here, that would be the state of Hawaii. The state must demonstrate that its regulation is consistent with the nation's historical traditions of firearms regulations. So the petitioners argue that Hawaii cannot meet that burden. Historically, Americans carried firearms in public facing businesses like taverns and shops, and that has happened since the founding of our nation. Property owners could exclude firearms through traditional trespass laws, but governments did not impose these default bans across all private property open to the public. That is a distinction that is critical, which was also raised by multiple judges on the Supreme Court. So now let's talk about what I think the outcome of this case will be based on the oral arguments. Based on the questioning at the oral arguments, here's kind of some realistic predictions that I have about how this could play out. Most likely, I think the outcome will be maybe a 6-3 reversal of what the Ninth Circuit said. The Supreme Court justices that formed the Bruin majority appeared skeptical of Hawaii's attempt to kind of reframe a broad restriction as a property rule. So Hawaii really tried to say this is just about trespass laws and property rights, but it seemed like a lot of the Supreme Court was skeptical of that position. Now, the key votes to watch for, however, are Chief Justice Roberts and then also Justice Kavanaugh. If they view this as a disguised kind of near total prohibition, the court will likely produce a solid 6-3 ruling and opinion striking down this law. Now, a narrower kind of 5-4 outcome is possible if one of those two, decides to kind of limit the scope of the ruling, maybe thinks that what Hawaii did was proper, then maybe you could get a 5-4 outcome. But regardless, I do think that we have the majority votes in favor of striking down this Hawaii statute. Now, one of the bigger questions in this may not be whether Hawaii loses, because I think we have enough votes, to beat Hawaii in this case. But, one of the bigger questions is how broadly does the Supreme Court rule in this case? The court could essentially issue a narrow opinion specific only to Hawaii's structure. And then, the downstream implications of that would be states like California and others who have similar laws would say, okay, this was specific only to Hawaii. And we're also going to say that we don't have to follow that ruling because, again, this was specific just to Hawaii. However, on the flip side, the Supreme Court could establish a broader rule prohibiting these default carry bans nationwide and say that that does not comply with Bruin. If the court writes broadly, this decision would immediately impact other states with similar default prohibition models, like I mentioned, California and others. This case is about whether the right to carry in public is meaningful. If states can convert, nearly all private property open to the public into default gun-free zones, then the right recognized in Bruin becomes hollow, and that case is really kind of done away with because states could override it. If the court strikes down this, clearly and firmly, it reinforces that the Second Amendment protects practical public carry, not just a theoretical license that can be essentially useless based on how a state writes a law. Now that oral arguments have completed, this case is under consideration in the Supreme Court, and we could see a ruling and decision by the Supreme Court, in late spring, early summer. The latest that opinions for this term would come out is usually late June, early July, depending on how they release some of these. But what we should be watching for going forward is how the majority frames historical analogs, whether the opinion reinforces, a strict adherence to that Bruin analysis that they outlined, and finally, whether there are any concurrences trying to narrow or expand upon that reasoning. And again, concurrences are important, and dicta is also important in some ways because we've seen, some dicta that has been put in various 2A rulings, various concurrences as well. And then you have anti-gun states or the federal government tried to latch on those to pass anti-gun laws. So that's also something we will need to watch for. So that's where things stand right now in the critical Wolfer versus Lopez case. Oral arguments are now done. The justices have signaled maybe serious concerns about this Hawaii law. And likely, and based on my opinion and listening to the oral arguments, I think that we're looking at either a 6-3 ruling striking down this law, or at the very least a 5-4 ruling striking down Hawaii's default carry ban. And again, that would impact a lot of other states and a lot of other laws that are currently in place after Bruin, trying to work around Bruin and essentially still ban concealed carry. So that's where things currently stand. As we get more information, as it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of content and it should share it to more people. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.